Hi, everybody, and welcome to the Sustainable Economies Law Center Teachgiving, day one of a three-part series. I'm really excited to be hosting today, and I wanted to take a quick minute to thank everyone for, well, because it's Teachgiving and we're approaching a holiday where people frequently give consideration to the things that they're grateful for. I wanted to say thank you to everyone for joining us today, taking time out of their busy schedules. I'm going to be sharing some information about my family. And so I wanted to also take a minute to say, I just wanted to give a little bit of context to the conversation today. My family and I should start by saying I'm a legal apprentice with SELC and co-director of the Radical Real Estate Law School, and really excited to be on this journey with some really amazing people. I wanted to take a couple minutes to share a slideshow that I put together to help kind of feed people's imagination today as we start our conversation around squatting and adverse possession. I think that a lot of people have some preconceived ideas about squatters, and so I've worked pretty hard to challenge people on that and to encourage them to expand their imagination about who squatters are and what squatting looks like. So I'm gonna slide into a slideshow, and I'll share some information about it. But first I wanna say that squatting is really difficult. And when I undertook that endeavor with my family, I had no idea what I was doing. We were motivated out of desperation and need. And so we didn't do a lot of strategizing. We just kind of looked at houses and identified one that we thought would work for our family potentially. And as the day approached where we were losing our stable housing, we just took the leap of faith. And initially, my family thought that we would kind of live in this house very short term, and that we would just bring it into a state that would make it safe enough and comfortable enough for us to do that. But another thing that I'm incredibly grateful for is the amazing community of people who came together and supported us in this effort and really made it possible. People kicked in so many different ways, from helping us with repairs on the property to just providing moral and emotional support, because it was very stressful and difficult. And one of the people that I am incredibly grateful to is somebody we're fortunate enough to have as our presenter today. When my family and I opened a house and moved in, we'd never heard of adverse possession, had no idea what it was. And about a year into living in the house, the bank came, and when we weren't home, the bank came and cherry picked all of our personal belongings, electronics, jewelry, all kinds of things. And even before that, I'll say, my kids, this happened during a very formative time for them, and they were young, and so they had a lot of questions that I was having a really hard time answering. And so I started looking online to see if there were other people who might be able to help me explain it to my children in a way that made more sense than I was able to that point. And that search produced a land action result on the inquiry, and that's how I came to meet Stephen DeCaprio. So not only is he our presenter today, but I'm also dedicating this little slideshow to him, because without his support, we wouldn't have been able to stay in the house. Like I said initially, we thought we'd be in the house for a very short period of time. And we thought we'd just fix it up to meet our basic needs. But the community of people that helped us really rolled up their sleeves and helped us bring it into a state that was more comfortable than I imagined possible. And when I reached out to Stephen and the people at Land Action, they were amazing. My entire family showed up to a meeting, and they just embraced us and made our family their agenda for that day. And they really helped me understand a number of the things that were contributing to why my family found ourselves in the circumstances and situations that we were in. And it helped me it helped me to be better prepared and able to help my kids understand why we were exercising the option that we chose, which for us was an alternative to homelessness or relocating out of the area. So and the slideshow is intended to give people a little bit of food for thought and to help you expand your imagination around what's possible. So give me just a second. This is the house as we found it. So I will speed through these, but people are welcome to ask questions in the chat as things come up, and we've made sure that there's time to answer some of that. This is the house in the condition that we found it in. There weren't, so you can see that hole in the wall there. I imagine that was put there so that people wouldn't have to go through the house to get out the front door. Interesting. And the house is on 45th and Ignacio in East Oakland, across from Fremont High School. We were fortunate enough to know the person who, when we came upon the house, it had been in a protracted state of foreclosure for about 5 years. And the mortgage company decided to leave it in the name of the former owner. And we became acquainted with her, and she was very kind and very gracious. She did not call the police. And when the bank did show up at the very end of the foreclosure process, so they could inspect, she came on property, we granted access. And even though they really strongly encouraged her to call the police, she chose not to. So we honor, respect, and appreciate her as well.
Christine, we see your folder and little thumbnail pictures of the house instead of the entire picture.
You can't see what I'm looking at. Okay. I'm not sure why. Let me start again with the, thank you for bringing that to my attention.
Yeah, just maybe if you choose the screen that is showing the picture in full.
It's possible when you said share screen, you chose the wrong window to share. Like you may need to share everything on your computer.
Okay. Let me see if I can figure that out.
You can unshare and then share again.
Thank you. Is that better?
Perfect.
Great. Okay, thank you. I'm just gonna buzz through these quickly. So as I'd mentioned, this is the house in the condition that we found it in. And you'll see as I go through a number of people who really showed up for us in a big way. There are a number of people in attendance today who were also part of that community who made this possible. We were able to live in this house for 3 years. And I met Stephen and Land Action a year in, and they really helped me expand my ideas around what was possible in this situation. We did consider adverse possession, but it wasn't a viable option because the bank had paid the taxes on the property. And so it wasn't really a candidate. And it's a blessing in a lot of ways because some people may know that this is the first but not the last house that we squatted. The second house was in a multi-unit building, and that endeavor resulted in the purchase of the house by Bay Area Community Land Trust. And so we've had, when this house came to a close, when our time at this house came to a close, I just want to bring your attention to my little one, and you can see her grow as we stayed in the house, as we made it our home. We did a lot of work in the yard. The yard was a big source of pride because you can see that the yard is very exposed. It's a chain link fence. There's a school directly across the street. And we were very open with our neighbors about what we were doing because I just didn't know, to have any concerns around that. I mean, I had concerns, but I wanted to engender trust. I wanted people to welcome us and embrace us, which they did in a really remarkable way. So this is us building retaining wall and getting the yard ready to, use in a way that suited us. You see, we had lots of helping hands over time, like all of the projects. And because the yard was wide open, all of this work was really an act of faith, because it took a significant investment of time and energy and social capital to pull it off. And you'll see as the kids grow, so do the sunflowers. So we had 3 seasons of sunflowers, and it was our gift to the neighbors. People would go out of their way. This is my kids' first day of school, first day back to school. As the plants grew, some of our neighbors would walk out of their way. So I included this picture because I wanted people to see me smiling, because it was a game changer for us to have housing security again, or something that, this is the notice. Once the house did go up for auction, I went to the auction and showed up with a flyer and handed it out to all potential bidders, just giving them a heads up of what they were in for. This is the house, us living in it and being comfortable. And every time we planted in the garden, you see the sunflowers and everything growing. But every time we planted, it was really an act of faith, because we didn't know if we would be around long enough to see the flowers grow. But we made it 3 years and 3 crops. And you can see the transformation, not only in the property, but in our family. This was actually move out day. It was really hard for us, but we were fortunate enough to get a 3rd season of flowers fully bloomed. And so on our move out day, it was time to harvest. And see how much Sophia grew of the process. That's when we started getting notices. And when we moved out, it's hard for me to share this, but when we moved out, we didn't really have a next step. Housing had not gotten any more affordable. And so our family sheltered ourselves in a combination of options, including U-Haul van, U-Haul truck. It was also during fires. And then we'd given up a U-Haul to have the luxury of a hotel room for 2 nights. And when we tried to book again, it was Burning Man, and there were no trucks to be had, and there were no rooms to be rented because of the fires. And so that's Sophia Luna sleeping in the U-Haul. But I share that with people because I want them to see us and to understand that this is something that it's a tactic and strategy for survival because of the circumstances that we find ourselves in. And that was my tribute to Stephen, who I am eternally grateful for. And I appreciate him being here today to share some of his wisdom and knowledge. I appreciate him for his leadership. Since meeting him, I've also had opportunities to collaborate with him on other projects when he was the executive director at the Meiklejohn Civil Liberties Institute and other things. So without further ado, welcome, Stephen, and thank you for joining us.
Thank you. So yeah, it's really, thank you, Selk, for having me here, and I really appreciate your kind words. And what I'm going to do is jump in and do the screen share, and hopefully I can do this right this time. All right, let's see what happens. All right, here we go. So, and just to give everybody a little bit of background about who I am, my name is Stephen DeCaprio. I am not an attorney, as the disclaimer says. I first started learning about housing occupations. Well, I mean, this was something that, I've been involved with for a very long time. But what really got me started in becoming an expert on the issue was becoming homeless in 2000 after the dot-com boom. In the summer of 2000, I lost my housing and was couch surfing and eventually living in a van. And I had experienced housing occupations in Europe when I was on tour with my bands, Lesser of Two and Embers. Um, and when I came home and became homeless after those tours in Europe, or after my first tour in Europe, I um, thought, well, I never thought that we could ever really replicate what was going on in Europe, these occupations. But, as a matter of survival, it became necessary. I was homeless for until 2006, homeless or squatting, so living in this ongoing state of housing precarity. And so this disclaimer, I do want to make it known that I'm not an attorney. I have been prevented from practicing law because of the opinions that I've expressed, and these are only my opinions and my opinions alone. They do not represent any organization. They do not represent the host, Selk. And this is not legal advice. And I think this is really important. I don't guarantee the accuracy of any information I provide. Even though I am often asked by lawyers about these issues, and I'm considered one of the top, most knowledgeable people in California on adverse possession, you should do your own research. Anything that I say is not an answer. It's just the beginning of a question, the beginning of a search. So I do really believe that in this portion of the disclaimer that that I can't guarantee the accuracy of any information, and no one is the ultimate authority on anything. We all have to work together to develop best practices and learn, because the moment that somebody thinks that they have all the answers is the moment that they've really fooled themselves. So yeah, it is your responsibility for everybody here, if you want to take any action based on this information, to verify its accuracy and move forward accordingly. So to do that, I would highly recommend, if you're in Alameda County, the Alameda County Law Library. When I was homeless, the law library was practically a second home for me, because I was continuously in litigation over various housing occupations, ones that I'd been removed from or ones that I had been that I was presently occupying. When I was before the state bar, in my state bar appeal, they had 6 file boxes of cases that I had been involved with over the years. And so the law library was a huge resource for me, and that's pretty much where I learned almost everything I know about the law, as far as research. So that's the website URL, and it's lawlibrary.acgov.org. Because of the pandemic, I believe the law library is closed, but if you go to their website, I believe they've expanded the amount of online resources available. So anytime I reference the law or a legal theory or a concept or a strategy or a tactic, I encourage you to do your own research and make sure that those laws are still in effect, they haven't been modified, and that they are applicable to your situation. So this is my home. When when I first encountered it, it was totally uninhabitable. And this was my house after 10 years of work. And so this, I include this just to ground this in what's possible, that, Christine's experience, my experience, and the experience of others is that by taking action, occupying land, you can house yourself and you can be successful. That is the takeaway here, and there's numerous successes we'll talk about later. So the theme of this is Thanksgiving, and I'm sure many of you have seen this image before. This is the image of the first Thanksgiving that as perceived by the European settlers, this was the perception that was projected for hundreds of years, that there was just this whitewashing of history where the pilgrims landed and just had this kind of kumbaya moment, and then everything was nice. However, some of you may have seen this image, which is the image of the Trail of Tears. And so that is kind of the dissonance in which we find ourselves in this week. The dissonance of this European colonizer narrative of Thanksgiving, and then the reality that Indigenous people faced. So this is something that came out recently. European settlers have killed, according to the carbon footprint, or the lack thereof, researchers have estimated that 56 million Indigenous people were killed in the Americas by colonizers. It actually created a mini ice age, because so many people were killed, and so many communities were basically taken over by, and farming communities were taken over by forests. So the other image of Thanksgiving that a lot of us encounter is this. On Alcatraz Island, every Thanksgiving, there is a ceremony to commemorate the real history of colonization in America. And the reason I bring this up is not just to go on a tangent about the Thanksgiving tradition that came from Europe and the juxtaposition of history on its own, but to also tie that to land, and to tie that to a deeper history of where all of this came from, as far as land and occupation and the various fundamental concepts. So the interesting thing about Thanksgiving is that it is a celebration of the fall harvest. And so what it celebrates is at least that's one of the things that's said. And so the harvest itself really started about 4,000 years ago, when humans started planting crops. And so here you see the Fertile Crescent, ancient Mesopotamia, Egypt, Phoenicia. And about 4,000 years ago, when crops were planted, the concepts of land were developed, and land ownership. And so these laws go back thousands of years. And a couple things that came out of this was that, first of all, there was, or maybe not first, but one of the things that came from this is the concept of colonization. So when you harvest the crops, the surplus food is then, was taxed by the Egyptians, and those taxes were used to feed standing armies. And basically, this created a system of agriculture, taxation, war, slavery, colonization. If you were not able to pay taxes, i.e. raise crops or produce anything, you were enslaved. And conquered people were enslaved, and their land was given over to the citizens of the colonizer in the Fertile Crescent. And so this concept of colonization really evolved as a kind of direct result of the rise in agriculture, as did slavery, and as did the concept of the ownership of land, and also the concept of the ownership of people, the ownership of animals, the ownership of things. You see this tablet here. This is a tablet from the most ancient legal treatise as it were, which is the Hammurabi Code. And under the Code of Hammurabi, the concept of property came about 1754 BC. And so that's the oldest known record of the ownership of land. And the ownership of land concept relies on agriculture, because in a hunting gathering society, you don't need to, make manufactured, constructs about if I'm going to draw this line in the sand and everything on this line I own and everything on that line you own. That concept doesn't really, it really wasn't necessary until people were planting, crops, and would plant the seeds in one part of the year and then have to come back to the same fixed location, and didn't want somebody just taking their food. So, Hammurabi, for the purposes of controlling this, tethered the concept of property rights to taxation. And so you can see here that and this isn't written into the code per se in Hammurabi, but basically Hammurabi wanted everyone to make sure that their land was being used to produce food. And so basically, if you were not producing food and someone showed up and took over your land, your house, your garden, and your field, and used it for 3 years, they would then be the owner of that property. And the whole reason for this is so that Hammurabi could feed his armies. And so this is the law 4,000 years ago, give or take. This is the law in California today. Not much has changed, except under Hammurabi, it was 3 years. Now it's 5 years. There's been some language added because lawyers have been really have gone over this quite a bit in the last 4,000 years, but I think it's surprising how little has really changed. And so really all of this, and they expressly added taxes. And so all of this is to ensure that the occupation of land in a quote unquote civilization is inuring to the benefit of those in power, the taxing authorities. So the question is, how has this been used? As one of the questions, I mean, there's numerous questions that can be raised, but one of the questions is, how can these laws that are so inherently tied to subjugation, colonization, and slavery, how can they be used for the purposes of developing tactics for movements and liberations? How can they be used against the very systems of oppression that flow from these 4,000 years later? And one of the initial things that occurred, and this is not really necessarily liberation per se, was that one of the paths to not be subjugated was to be the person to occupy the fallow field. The question being, though, are you occupying the land in colonized land as part of the expansion of a territory, or are you finding land that's unused in your own community? So that's a question, but at the very least, you are being able to pay taxes and avoid being conscripted into Hammurabi's army. Unfortunately, the people of the Fertile Crescent, my ancestors are Phoenician, and my ancestors, unfortunately, as the term Phoenician indicates, taught the phonics of language to the Europeans. And so the people of the Fertile Crescent then basically exported these concepts to the Europeans, who then adopted these concepts of colonization and slavery and expanded them. So here you see an image of the feudal system developed in Europe. And Europeans did make some developed some interesting concepts that expanded the oppression of land and property ownership. One of the ideas that the Europeans added to this whole mix of things is the concept of capture and occupation. Under Hammurabi, the idea was you would only get rights after the 3 years. However, the English really wanted to promote a kind of smash and grab kind of orientation, that anything that was captured was owned by the person who captures it. And so this means that ownership doesn't vest after 3 years. It vests at the moment of capture. Of course, this is a concept that was used to support slavery, and it was also a concept used to steal land and colonize territory, because if you could just capture land, that was much easier than Hammurabi's code, which required you to occupy the land for a period of time. And so what the English did was basically decided that if something was in quote unquote a state of nature, you could capture it. And so that applies to land as well. And so when land is quote unquote abandoned, and you can prove it's abandoned, the English thought that that meant you owned it upon the moment of occupation. So this is what the Pilgrims saw when they came to Plymouth Rock. This is not what they saw. This is what it looks. This is the national park near the point of Plymouth Rock. And this is what we turn things like that into. This is the LA River. So, under the concept of Hammurabi, under the English concept of property law, nothing has any value unless it's captured and occupied and converted to a use that is recognized by those in power. So I say all this just to honor this week and the Thanksgiving commemoration, some of us refer to it more as a period of mourning, and to really understand that when we use these laws, that these laws were never meant to benefit us. They were meant to benefit the ruling class. And I think it's important to remember, because I think that if you just read the laws and you don't ground yourself in history, you can definitely, and I think a lot of the people in this room understand this very, very much, but you could really set yourself up to fail if you're not aware that these laws were designed to serve the ruling class. If you're really interested in digging into these histories and how the history of colonization, oppression, and intersects with movements for housing and land liberation, these are two really amazing books, actually. Property Outlaws: How Squatters, Pirates, and Protesters Improved the Law of Ownership, and then 9/10 of the Law: Property and Resistance in the United States. There's some really great stories, and you could really dig into these concepts much deeper than what I've just laid out. So I'm going to do with that said, another disclaimer: cops are going to cop. And, so I think that the presentation I just gave leading up to this should indicate that, when the laws as they're written benefit those who are not in places of power, then often the laws are not followed by those in power. So knowing the law is not enough. Police, lawyers, public officials, and courts often disregard the law when the law does not serve their interests or the interest of those with money, status, or power. In order to navigate systems of oppression, it is essential to understand those who maintain the status quo, as well as potential allies to challenge oppression. So yeah, these laws were not written for the people, but the people but this is what we are contending with. We should know the law, and we should be aware of it. And when possible, we should, do our best to use these laws to our advantage. But with that said, this disclaimer: what we can do with these laws is limited. So let's get into it. So based on what I just stated, there are really 3 phases in California for adverse possession. Adverse possession is, as I stated, it's the law of occupying land to claim ownership. So the first phase is the initial occupation. This really comes from the theory of capture that I mentioned that the English came up with under Civil Code section 1006. Occupancy for any period of time confers title. Second, in California, this is something this is more of a modern invention. In California, there is after 1 year, you are entitled to full procedural rights. And really, this is really a contraction of the rights, a contraction because within the first year, you are subject to potentially being summarily evicted. So the 1 year mark is actually something that the initial colonizers did not have to contend with. This is something that was produced as part of an anti-squatter, anti-tenant framework. And then, of course, the 5 years, which we mentioned. So, yeah, this is not the situation you want to be in. You don't want to be talking to the cops, and telling them, hey, the law says this, the law says that. They don't care. Generally, I mean, I'm not going to say that about not all cops, quote unquote, but very rarely can you, in the streets, litigate your rights. I know a lot of lawyers get all immersed in the law and then suddenly convince themselves that the law is real and that it actually makes a difference in like the streets, but it doesn't. The cops are going to cop. So the most important thing is being a good neighbor. Well, not the most, but a very important thing is being a good neighbor so that your neighbors don't call the cops. And what that means depends on the neighborhood. It depends on you as well. I mean, if, how do the neighbors perceive you, and and what kind of positive relationships can you build? Are you going to be best friends with the neighbors, or are you gonna, are you all gonna just nod at each other in the street and just, tolerate each other? I would any of those options I would be happy to have if you're occupying an abandoned property. But yeah, topiary is number 1, making sure that in any neighborhood I've been in, and I don't know what everybody else's experience here is, but every neighborhood I've been in, when you do some topiary, fixing up making it look nicer, that's one thing that will start, getting people on your side. So yeah, this is how my property looked after about 10 years, and more or less what it looks like today. And so yeah, a lot of the neighbors do like our garden. So I think gardening and lawn maintenance, I think it might seem like a superficial thing, but our neighbors often care about those things more than they care about us. So it's, strategic. So as I mentioned, Civil Code section 1006, it's, this theory of capture. So occupancy for any period confers a title sufficient against all except, and then it lists the other types of title, which is basically everything else. You can never claim title against the state. So property owned by the state is not, you can't claim title to that. But anything else is possible if it's private property. And there's different things that can happen if somebody shows up with a superior title. So the titles that are listed here by prescription, accession, transfer, will, or succession, those would all be superior titles. However, one of the questions that always arises is just because someone says they have one of those titles doesn't mean it's so. So, just because someone comes up on your doorstep and says, I'm the owner of this property and get out, that doesn't, that's not always true. So you always have at least the right to you know, ask if that person, you know, has some proof and you know, get it proven. Um, so they're, you know, usually you have that right. One way to really find out before you're in that situation, though, is to research the property. Um, this is the Alameda County Assessor's Office website, and I recommend that, highly recommend that if anyone's thinking about doing an occupation of any form, whether it's a direct action, whether it's housing, whatever it is, or, you know, solidarity work, you know, this this kind of, it's really important to do your research. A lot of organizers go out and just do actions and haven't done their research, and it usually blows up in their face. But if you do your research, um, you know, you might surprise a lot of people. And what I found is, if you find you know, a dozen abandoned properties, or properties that appear to be abandoned, and you research them, you'll find one or two, at least in my experience, and I'm not sure what it's like on the streets right now, but um, where the owner has just totally disappeared, or it's a weird situation, you know, or it's a bank owned property, or it's owned by some speculator who's bought hundreds, if not thousands, of properties. And, you know, there's really a path forward to, for an action or for an occupation. um, and so going to the assessor's office, highly recommend that. You can purchase a CD from the assessor that basically lists all the properties in Alameda County, and tells and says, and it's basically a spreadsheet of all properties in the entire county and all the owners of those properties. That's a really good spreadsheet to get. And I think it's, I don't know, $5, $25. I don't know what it is. It's, you know, it's worth it. And, you know, if somebody gets that, you could just share it with your friends. Maybe everyone pitches in. People on this call maybe could get together and pitch in on it. But the other thing about the assessor's office is that, and here's the website, is that on the third floor, they have computers that you can research properties, and not just find the ownership you know, information now, but also see the history of ownership. And that's really important, because sometimes with abandoned properties, the current owner, that information is less important than the previous owner, because it may be in, you know, it might be in probate or something like that, and you kind of want to know, you know, get a little bit of information about who owned it. And or it may be that the current owner is, you know, it's not clear who they are based on the information that's provided. So you want to see, kind of look at the previous owners, to kind of get a sense of what's going on. It's always good, I think, to look at the previous owners, just to get a sense of the history of the property, you know, to know if it was recently purchased, if it was purchased, you know, 20 years ago, 30 years ago, and has been sitting there abandoned forever. All of that kind of gives you an insight. But one of the things I always recommend before occupying a property is to be very exhaustive in your research. Don't just find out who the owner is. Talk to that person. Like really make a vigilant, diligent effort to reach out to the owner, because it's better to engage with that owner and have them yell at you on the phone than to yell at you while you know, just renovated a building and have the police at their backs. So I always like to make sure that you kick the hornet's nest, to make sure before you get into it. You know, I really recommend this. A lot of people kind of convince themselves, oh, well, it looks like a good thing, and I just don't want to, you know, yeah, you're just setting yourself up to fail. You know, unless it's an action or something like that, where you are looking for engagement with the owner, like Moms for Housing or something like that. Maybe that's what you're looking for, and that's part of a larger strategy. But you know, definitely do your due diligence and research. And I would encourage people to, you know, not be fixated on any one property, but to look at where opportunities lie. Being opportunistic is probably a better strategy than fixating on a particular location that you think is ideal for your occupation or action. So yeah, and here's how, this is the information on getting that, the more in-depth property ownership information. You know, I'd encourage you to, if you can, take a screenshot of this. And, you know, when the pandemic is over, you know, but you can also call them up at this number and ask them who owns this property. So, you know, and they'll tell you that you just can't keep them on the phone and ask them 100 properties. They'll only tell you so many parcels at any one time. So now let's get into a little bit of some tactics that you can use. So when you're occupying a property, one thing that you can do is invoke what's called Revenue and Taxation Code Section 610. So, and what this does is you can, and this is a form that we've developed at Land Action. No form really existed for it, but the law provides that somebody who is occupying land for the purposes of making a claim of adverse possession has a right to have their name inserted into the assessor's roll. The assessor's roll, and let me just back up a little bit what the assessor does and what the tax collector does. The assessor basically determines how the value of a property for the purposes of taxation, and the tax collector then levies taxes on that property. In Alameda County, we have an assessor and we have a collector. Other counties have, it's just one office, and I don't know why we have two. But the reason why this is important is because when anyone looks up a property, except in the recorder's office, but if you look at the database, this is the database used by law enforcement. This is the database used by a lot of you know, online resources. What they'll look at is the assessor's records as the definitive database of who owns what anywhere. So the fact that in California, a squatter has the right to insert their name into the assessor's roll is a really big deal, because that means that you're the assumed owner. And what we have found is that with the Oakland Police Department, it comes up on their scanners. So when they look up a property, whatever name is in the assessor's record is what is the name that they see. Now, this is a mixed bag. So you need to, you know, if before you run out and do this, you know, keep in mind that you are telling the assessor that you're squatting this particular address. So the police may show up and see that your name's listed, but the assessor, what the assessor does to kind of rat you out is they put next to your name per Revenue and Taxation Code 610B3. So I don't know at this point where we stand. When we first started using this form, the Oakland Police Department would not harass people occupying land. But, you know, I don't know if that's true today. Circumstances change. The Oakland police may be understanding what 610B3 means. They didn't understand that, you know, a few years back, but maybe they do now. Also, I don't know whether the district attorney's office and the assessor's office are, how much they're coordinating their efforts to, you know, basically thwart people's adverse possession claims. I know that in the city of Berkeley, they have a long-standing policy of proactively identifying squatters and rooting them out, even going so far to root squatters out of properties that are otherwise abandoned and no owner has shown up. They'll actually, in one instance, the chief of police said that someone was wanted to squat a property, and they couldn't find the owner, so they found someone who had been committed, who was no longer had any agency, and the city of Berkeley proactively found someone to be designated as their you know, as having a power of attorney over this person who was themselves not competent to represent themselves, and then got that person to sign paperwork so that they could arrest anyone who entered the property. So they went that far out of their way to concoct a a victim. And so the city of Berkeley will concoct victims just for the purposes of preventing adverse possession claims. And this is what I learned in Berkeley, which is why I don't squat in Berkeley. So other documentation that you can use, a Homestead Declaration is something that can be recorded. And you can find, you can find these documents in the Alameda, County Law Library. And a Homestead Declaration just is something you can record with the Alameda County Recorder's Office. The Alameda County Recorder's Office is another place that people go to determine who owns what. The Alameda County Recorder's Office, which I did not include a slide here, they are also a place where you can look up whether a notice has been recorded as to a foreclosure. So that's a place where you can find information about pending foreclosures and other kinds of activity in which, there are efforts to basically take property away from homeowners. And this is something that people have used for solidarity work, to stand in solidarity with people facing foreclosure. But the Homestead Declaration can be recorded at the Alameda County Recorder's Office, as can these other two documents. The Homestead Declaration basically just says that you are residing at the property. So make sure you are residing at the property. Otherwise, it's not appropriate to record this. The one thing about the Homestead Declaration is that it can be used as evidence. So if you do actually fulfill the 5 years and go to adverse possession, it can be something that you use as evidence to support your claim that you are on the property physically, because it's presumed to be true unless evidence is provided that states otherwise. There's a presumption that you are occupying the property because of this. The notice of intent to preserve interest, that's an interesting one, because I've only used that, and I've never had, it's never really been something that's been a game changer or helped in any kind of litigation thus far. But it is something that if you are improperly removed from the property and you want to record something, the notice of intent to preserve interest can indicate that you're not abandoning your claim of adverse possession. And that's what I've used it for. It inserts your name into the ownership index. But if you're occupying the property and there has not been anyone challenging your claim, I don't see any legitimate reason to record this. A quitclaim deed can be recorded, but that's for transfer of title. So don't do what Denman did in People v. Denman, and I encourage you to read this case. In People v. Denman wrote a quitclaim deed from themselves to themselves, and they were found guilty of fraud. So I would discourage anyone from signing and notarizing and recording a quitclaim deed unless you are actually transferring your interest in the property. And so if you occupy land, you are the presumed owner pursuant to Civil Code section 1006. If you leave the property or wish to add other people to title, you could then do a quitclaim deed. It has to be a transfer from one person to another, or to add people in interest. So what Land Action would do was, we would basically have the people squatting properties record a quitclaim deed transferring their interest to Land Action, and then we would enter into a property management agreement. There's a case called People v. Lapcheski. Lapcheski is spelled Lapcheske, in which it states that a person occupying land has the right to rent out that land. So People v. Lapcheski supports the concept that one could create a corporation and then transfer title to that corporation and have the people on the property being tenants or in our case, property managers. we were, and just to be real with you, we were charged with conspiracy for doing this, and we won. So, you know, the upside is we won the case of conspiracy, but we had excellent lawyers. And so the question is, how much of any of these things do you want on the record? So, especially a quitclaim deed where you're transferring title back and forth, you know, and then that gets challenged. So just be cognizant that, you know, just because the law says you can do things doesn't mean that the courts or the cops are going to respect the law. Because, you know, and I should just say before we, you know, I just want to say as kind of an aside of, you know, how, you know, what has happened that's created this cognitive dissonance between the law and systems of oppression. And one is, you know, one of the things that has occurred is the commodification of land. You know, the buying and selling of instruments based on debt. And what that has done is kind of really broken the system that was designed by Hammurabi and was really developed by the English. That system really does function on, you know, the physical occupation of land and having, you know, there be a clear connection between that occupation and the ownership. Once that was severed during the foreclosure crisis, and, you know, that was leading up to now, it really made it so that a lot of these, you know, ancient laws stopped really serving the interests of those in power, because those in power wanted to commodify land, not occupy it. So that's kind of why during Occupy Wall Street, when we did about a dozen actions using these concepts, that the law actually started working to our favor, and it was the courts that started ignoring the laws. And so, yeah, there is this cognitive dissonance with the commodification of land that is really forcing the law to be no longer serving the interests of those in power as it once had. And so with that said, there are things that can be used against you. The concept of criminal trespass, it's actually a very new concept, and it was only developed, you know, a lot of these newer concepts of law were developed once poor people and oppressed people started using these laws to our advantage. And so the idea of criminal trespass was after, you know, after the US defeated Mexico in, you know, and took, basically colonized both, you know, Texas through California, the idea of criminal trespass, you know, kind of came into being. The United States actually led this concept, and it was England that later followed it. There is actually a funny case where a guy jumped the fence in Buckingham Palace and terrorized the Queen, and no one could figure out what, you know, if there was any crime that he committed. So they actually followed the U.S. lead and created this concept of criminal trespass. So the criminalization of homelessness really started with the concept of criminal trespass being a thing when it didn't used to be. So that said, you know, what is criminal trespass? Well, on the books, it's a misdemeanor. So, you know, anyone who's doing any of this stuff, no matter what the law says, you are risking being at least accused of criminal trespass. And so if you're going to risk being accused of criminal trespass, even if the property is abandoned, you've crossed your T's, dotted your I's, done your research, and like researched the law and concluded with the best of your diligence that yes, this is an abandoned property that is, you know, appropriate to be occupying for the purposes of making a claim of adverse possession. Even if you've done all of that, there's still a risk of being accused of criminal trespass, and there's still a risk of being prosecuted and convicted of criminal trespass. You know, the property where I was speaking to a police officer in a previous slide, the property was abandoned, the owners were deceased, and there was no person that could prosecute their, you know, criminal trespass requires a victim. And so there was no legal nor factual grounds for prosecution, yet I was arrested and prosecuted and convicted nonetheless. So, you know, take all of these laws with a grain of salt, because the courts, you know, the cops, public officials, judges, and courts really don't give a damn about the law. They're going to do what they're going to do to support, to basically defend their interests. So, but it is interesting because they sometimes have that cognitive dissonance. One thing I will say, is, it's just a risk analysis. Ask yourself, what is your situation, and is the risk of a misdemeanor, which this is the maximum 6 months, $1,000 fine. I mean, there could be aggravating circumstances. For example, a conspiracy to commit a misdemeanor is a felony in California because California hates poor people and really wants to put people who are homeless in prison. So we face that, and so sentences do go up when they have those aggravating factors. In my case, they basically convicted me of 3 misdemeanor trespasses. Well, 6, but 3 on 2 different theories. So they were saying they could pile up the time, and basically what their theory was that if you're occupying a property on a Tuesday and you get a citation, and then you're occupying it on a Wednesday and you get a citation, and you're occupying it on a Thursday and get a citation, then that's somehow 3 trespasses. So at any rate, so that kind of means that you could, in theory, it's you might be subjected to infinite punishment, I guess. But generally speaking, in reality, though, misdemeanors, they don't want to put you in for more than a few months, if they put you in at all. Usually, if depending on of course, depending on your circumstances, it varies from person to person how heavily you're criminalized or how little you're criminalized. So yeah, Penal Code Section 19 is the punishment if you're convicted, and the framework is Penal Code Section 602. There's a laundry list that goes from A through, I don't know what they're up to, Q. They keep adding new offenses, and keep I don't know. So it's this laundry list of offenses, really designed to break the will of poor people and movements, and and of course 602.5 is another one, and that basically prevents you from squatting someone's house while they're on vacation. So please don't do that. I really discourage you from occupying someone's vacation residence. I mean, unless you really just don't like that person and that's part of the action, I guess maybe that's a civil disobedience question, but from a legal standpoint, you're violating Penal Code Section 602.5. So what are the defenses to criminal trespass? Well, the Fourth Amendment, King v. Masarwe, requires that you can't there has to be some evidence that you're trespassing. It can't be just that you don't own the property. What happened in King v. Masarwe was that the property owner claimed that the people were trespassing, and the people on the property said that they were tenants, and they were arrested for trespassing, and then it was found that and I'm paraphrasing the facts, so you should read this on your own and verify that I'm accurate. But basically, they said there's a presumption that if someone's on property that they're not a trespasser, just because someone says that they are, and so that's kind of a procedural argument. And so the Eighth Amendment question, Martin v. Boise, that is mostly for the occupations by homeless encampments and people who are unhoused, who are sleeping on the streets. It basically says that if there are not enough shelter beds available, that it's unconstitutional to criminalize homelessness. So someone can't be prosecuted for trespassing for camping on public land if they're not provided an alternative place to sleep. And the First Amendment, Ali v. Medrano, that they basically used trespassing as a way to harass farm workers who were trying to organize. And so, this is not anything that I've encountered as a winning argument. And really, to be honest, King v. Masarwe, I've never seen the courts follow that either. Martin v. City of Boise, though, we've been able to actually have some success convincing courts to follow that to a certain extent. I mean, they generally violate it ultimately, but they'll at least give homeless people, you know, a little bit of a day in court before the courts just kind of jettison people's legal rights. And you know, basically the courts are not following Martin v. City of Boise, you know, fully, but they're giving people a day in court, which is pretty valuable. So yeah, like I said, you don't want to be talking to the cops about all of this stuff and being like, and citing, you know, these cases and showing them all this stuff. It's usually not a good situation. And this is the house that I was arrested, I think 9 times or something. And, you know, cases were dismissed, cases I was convicted. And I just kept coming back. This was in Berkeley. And I discouraged you from following my mistakes in that case. And so, if you do avoid all of that, that's not the end of the story here. You're still subject to civil trespass laws, which are the civil trespass laws are much more ancient. It used to be that if you were on someone else's land, that it wasn't criminal per se, and if you were occupying their land, they'd have to remove you through a civil process. They'd have to go to court. And so what does this look like in California? Well, Code of Civil Procedure Section 1159 and 1160 are designed specifically to remove squatters. And their summary proceedings very similar to an unlawful detainer that a tenant would follow. And in Alameda County, the judges that I have encountered thus far have indicated that the procedure for this is the same as a tenant, except you don't have the defenses that a tenant has. So, you know, this is a fast track procedure, and, you know, this is something that, you know, I've seen these cases can take anywhere from if you don't show up to court, you'll probably be evicted in a couple weeks. It's just the amount of time for them to secure a default judgment against you and for the sheriff to post a notice on the property. However, I have seen people litigate these cases for as much as 8 months, but that's the outlier. But I would recommend, you know, if you feel like you have a strong case, you know, it's worth, you know, fighting these kind of things. You know, some of the defenses are, you know, that it's a title dispute, you know, and there's a case called Owen v. Dottie, which states that you can't litigate ownership in a summary proceeding. And Dottie is spelled D-O-T-Y for what it's worth. So, and that's a deep cut of a case. You're not going to find that on. Oh, and I would recommend, if you guys want to look up cases, Google Scholar is actually a good resource, but they don't have Owen v. Dottie there for some reason. You have to go to the law library, or go on a more in-depth legal resource. But I don't know. I haven't checked it in a while, so maybe it is on there. But yeah, so you can argue that. You can also argue like the process. You know, often they will omit names. You know, even if they know your name, I've been in cases where people know the names of the squatters, but then sue them as does anyway. That's illegal, and you can challenge that. You can file a motion to quash if you're not properly served. That's the same thing for tenants. So there's a lot of little things that you can do. I'm not going to get into all of them, but you know, law library is a good place to go for the procedural ins and outs of how you can defend yourself if you're faced with one of these types of cases. Of course, you know, there's always just trying to settle. You know, if you could come to an agreement, that might be better, because, you know, you have to ask yourself, how difficult is this going to be to litigate versus how, you know, how dire is my need for housing? You know, to be honest, it might be better to just sleep in a van, and, you know, if you can find a place to park it. Sometimes I think back and regret that I didn't do just that in some of these cases. And so the other civil trespass is quiet title. That is when you actually are litigating who owns the property. And that is the classic Code of Civil Procedure Section 1159 and 1160 are pretty modern inventions, these summary proceedings. Those were invented to really give more power to landlords and property owners. And so it's kind of an effort to kind of facilitate the commodification of land. But it's, before those kind of laws came into place, the English came up with this idea of the quiet title lawsuit, in which the two individuals who claim ownership, or the various parties that it's not necessarily two, it could be any number of people who claim interest in land, basically go to court and go through this full process, produce all their evidence, and everybody argues that the other person's evidence is bad and that their evidence is good, and that and so you just kind of go down. These cases are there is a limit on the time frame that a case in California can go before it's just dismissed for lack of resolution, and that is 5 years. Ironically, 5 years is also the adverse possession time frame. So if you're occupying land for 5 years, you become the owner. If you're occupying land and litigate for 5 years, you become the owner. So I saw a case, a very not popular, very well-known case among many activists during Occupy Wall Street in Oakland, where the occupants, and I was one of these occupants, but it just was a kind of revolving door of occupants who all just kept taking turns litigating this one case. That case went on for 4 years and 11 months. And so it was the trial occurred 1 month before the date that the owner lost the right to make any claims. So, I wouldn't. So that's theoretically possible, and I've seen one case where you get really close. But I think when you get close to the 5-year mark, the judges are really going to force a trial, and so I wouldn't count on being able to litigate for 5 years, nor would I encourage that. But hey, you guys do you. So, at any rate, the defenses, Code of Civil Procedure Section 1172. So 1172 is basically the law that states that you cannot be subject to a summary proceeding by forcible detainer or forcible entry if you've been occupying the land for 1 year or more. So that's a defense to the forcible entry, forcible detainer. And if you've been on a property more than a year, that's your defense. And in quiet title, obviously, if you've been on the property for 5 years, paying the taxes and fulfilling all the requirements under Code of Civil Procedure Section 325, which I'm not sure if I wrote this in this presentation, but you should jot that down. If you fulfill all of that, you're the owner, and so you should assert that you are and fight tooth and nail for your rights. However, if you haven't been on the property for more than 5 years, you do still have the right in a quiet title action to assert your rights as the occupier pursuant to Civil Code Section 1006, the capture, the occupancy concept, by arguing that the person that is claiming to be the owner is not the true owner, and you can force them to prove their title, and you can test it. And to be honest, with the commodification of land, many of these titles are open to question. There was one property that, for example, a person circumvented a bankruptcy proceeding to on the sly transfer title to another party, even though that they didn't have that power, and then that other party showed up and claimed that they were the owner. So there's often these kind of situations which someone who says they're the owner is not necessarily the owner, because you have to make sure that if a transfer occurs, that the transfer was valid. So sometimes people just say they're the owners and they're not. They've never, no transfer has occurred, and they just come up and say they're the owner. This happens all the time. And also sometimes somebody has received a piece of paper that states that they are the true owner because it's a grant deed or something that looks good, but people bought the Brooklyn Bridge. It doesn't make it so. So there's always it's always worth doing some research and not just taking people's word at it, and not just assuming that a document is valid because someone presents it to you. Anyone can create any kind of document they want. So, you know, if someone comes forward saying they're the owner, you know, verify. You can look in the Alameda County Court records. They have a department they've moved it to Alameda Island to kind of make it more difficult for people in Oakland to access. But yeah, I would look to see if there's been litigation. I would look in the recorder's office. I would also look in the assessor's office to verify, because just because someone has a piece of paper doesn't mean it's true. So, you know, but you don't want to be, you know, litigating and living in your van. Like that's, you know, so I encourage you to really be thoughtful about how you use these concepts, be realistic, be diligent, do your own research about the law, do your own research about any kind of property or action you're going to do, and really think it through, because the worst thing that you can do is be homeless and also be litigating one of these cases, because then you're just not even getting the benefit of shelter. So there is some good news. You know, like I was saying, Martin v. City of Boise, this has been used to defend homeless encampments in Oakland and throughout the West Coast. And, you know, my first encounter was with First They Came for the Homeless. We pulled together a you know, federal civil rights lawsuit under United States Code section, I believe it's 1983, USC section 1983, which is just your standard civil rights lawsuit. There's blank templates, and we further developed those templates for this specific purpose, so that if you're in a homeless encampment, or, you know, yeah, if you're homeless, basically, if you're homeless and you're getting harassed, you know, you can fill out these forms and go to the federal courthouse. And one of the things that we've seen is that with First They Came for the Homeless, the courts actually granted a temporary restraining order, which postponed an eviction pending the outcome of the litigation. Ultimately, they lost, and their leaders died from exposure. Or some of their leaders died from, you know, complications. And so, you know, fuck the police and fuck the city of Berkeley for being a bunch of assholes. And I'm sorry, but, you know, Clark Sullivan is dead, and so is Mike Zint, and the city of Berkeley killed them, as far as I'm concerned, and have killed many people. So yeah, so they use that, and you know, some of the people, though, you know, obviously people benefited, you know, having shelter, being able to be in your tent for a week or two extra, you know, was very helpful. And you know, and it made it so that it slowed down this constant cycle of harassment, where people would, you know, the police would show up, take all their belongings, destroy everything, and then people would be scattered to the wind to rebuild, doing that, you know, sometimes weekly. So now it's like it happens maybe monthly, and people are, you know, the comorbidities of homelessness and the pandemic are somewhat reduced. The village really operationalized this. They promulgated about 5 of these lawsuits, and really leveraged it into some political power, which I think is changing changing the ground upon which the city of Oakland is operating. And I think we're going to see, you know, how that, you know, in this post-election environment, how that plays out, especially with Carol Fife winning her race, you know, one of the people involved with Moms for Housing. I just, yeah, I you know, knock on wood, I'm hoping that, you know, a policy of mass murder is, you know, at least alleviated somewhat in the cities of Oakland and Berkeley and the state of California. So on that positive note, here is where you can find those templates. We uploaded them to the website for the Meiklejohn Civil Liberties Institute. And, you know, I encourage you to, you know, like I said, verify the information and modify as you see fit. as per the various disclaimers that I provided. So you can go to this website, and I'm sorry it's a long URL, but take a screenshot, and if you I don't know where your screenshot button is, but I think mine says print PRT SCR on the upper right hand side of my keyboard. And yeah, download these. If you're being harassed by the cops and you're homeless, this is something you can fill out and take down to the federal court, and at least get a temporary restraining order. But I would really encourage everybody to, if you can, maybe Selk could do something about this. I don't know, but if you could, twist an attorney's arm to show up before to help you with the preliminary injunction, that would be ideal, because what in LA occurred is, in Skid Row, is where the people of Skid Row really had a huge victory was obtaining a preliminary injunction. The temporary restraining order will just delay maybe for a couple weeks, but the preliminary injunction will, that could go on for years. And so that's why Skid Row has been what was so stable for, has been so stable, I guess. I mean, I don't know. I don't know much about Skid Row, but at least that's what the attorney said, is that getting the preliminary injunction was a game changer for them. And so, if you're going to run hard at this, if you just want to get a TRO and have some extra time, like I totally understand that. But if you want to run hard at this and have and get a big win, getting a preliminary injunction is the kind of the strategy that is recommended. And so getting an attorney involved, if you can, is ideal, but at least doing your research and really making a strong case for Martin v. Boise, because Martin v. Boise is very clear, and what the city of Oakland is doing, what the city of Berkeley is doing, what is happening throughout the state of California is a violation of Martin v. Boise. And it's just a violation of basic human rights. But the courts do at least acknowledge that Martin v. Boise exists in the corporeal reality in which the law is constructed. So they're just trying to wiggle out from any kind of, basically they're just saying that what they've been telling themselves is that, basically a thing is just not a thing. They basically just say the facts are not facts, and they say that Martin v. Boise is the law, but that the harassment of homeless people is not actually occurring, is what they've been saying, which is just, they've just divorced themselves from the factual reality, but they haven't divorced themselves from the legal reality of it. So, there's some, so if you can convince them that what the truth on the ground is, it's possible you could get a preliminary injunction pending further litigation. All right. So I don't know why I put the slide in here, but this is me at Occupy Wall Street in Oakland. Some people refer to as Occupy Oakland, others as Decolonize Oakland, and others as whatever. I don't know what other names have been given. But yeah, so one thing I will say is that the State Bar of California played clips from this to prove that I was unfit to practice law because I promulgated, I practiced law without a license. There's a guy in Oregon who is now serving time in prison for basically taking this presentation and creating a presentation of his own based on Washington law. And so he's been charged and convicted of practicing law without a license, and the State Bar refuses to give me a license for sharing this information. So, hopefully I don't go to prison for, telling people things, but hey, I will accept my fate, because information, we should not live in fear for sharing information. And the idea that the state mandates that we all live in ignorance of the law while we also are held to comply with it is complete and utter bullshit. And if I'm considered the top expert on adverse possession law in California by a large number of attorneys, then I should not be silenced. So I shared this with Occupy Wall Street organizers. This led to dozens of occupations, and it's been replicated in other campaigns since then, and to great effect. These were some people who were housed by a large occupation during Occupy Wall Street and coming out of Occupy Wall Street, and this is the house that they were in, and this is something cool that we did with it. But you know what's cooler than billboards that say what our values are? I mean, I think this is a win, but you know, being able to liberate a billboard for a day or 2 days or whatever. But I also like victories that are forever wins. So there is hope. You know, I feel like I've been a little bit pessimistic in this presentation, but you know, Moms for Housing occupied a property and leveraged that occupation to force the property owner through shame to transfer title to them or a third party. I don't know the exact elements of the transaction, and you know, they definitely use some of these ideas, as they use many ideas from many people before them, and of course, Christine, her family were successful in occupying a property. And you know, something I want to say about this is that there's also this kind of, you know, we need to be creative. And I think Christine is a very creative person, and I really love that a lot of you here are probably very creative. And I want you to think outside the box that I've put forth, and you know, really challenge some of the ideas that I've put out there. And one of the things that I've seen happen is, you know, this collaborative thing where you have an apartment and tenants work with squatters to fight, you know, against evictions and have that solidarity. So these multi-unit properties might be something that's, you know, going around and going to these multi-unit properties and working with tenants in solidarity. So solidarity actions might be an opportunity not only to provide solidarity to tenants or others, people facing foreclosure, but in these multiple units, it might also be an opportunity to house oneself and have that mutual aid. We also have had success with these empty lots, and you know, a lot of these empty lots are tax defaulted lots, and you know, Land Action for a while was part of a network of collective gardens that had tiny homes and gardens, and really worked to get community buy-in from this. So, and this is a garden that still exists and still provides housing. And so, yeah, and this is my wife, Terry Dawn, our dog Ramus, and I in front of our house looking very serious. And so, yeah, I feel that despite, you know, all the crazy shit that happened in my life leading up to this moment, I'm very thankful for all of it because I own my own home and I am housed, and I will never take that for granted. And something I'd like to share with you is that, you know, and I know that this is kind of dark, but it's also hopeful. But I'd like to read this from August Spies, who's one of my heroes. You gentlemen are the revolutionists. You rebel against the effects of social change, social conditions which have tossed you by the fair hand of fortune into a magnificent paradise. Without inquiring, you imagine that no one else has a right in that place. You insist that you are the chosen ones, the sole proprietors. The forces that tossed you into the paradise, the industrial forces, are still at work. They are growing more active and intense from day to day. Their tendency is to elevate all mankind to the same level, to have all humanity share in the paradise you now monopolize. You, in your blindness, think you can stop the tidal wave of civilization and human emancipation by placing a few policemen, a few Gatling guns, and some regiments of militia on the shores. You think you can frighten the rising waves back into the unfathomable depths whence they have arisen by erecting a few gallows in the perspective. You who oppose the natural course of things, you are the real revolutionists. You and you alone are the conspirators and destructionists. August Spies said this to the court prior to them sentencing him to death. And this, for me, is why I believe that it's essential that for me to say truth to power and say that we need to end homelessness and ensure that all people have housing, all people have the human right to housing. And, you know, the power, the laws, and the people that they were purported to support are so brittle. We see that as these artifices of constructions of law stop serving those in power, and then those in power themselves embrace lawlessness, that these laws no longer serve them because of the changing circumstances upon which they find themselves. And so it's really up to us to change those circumstances, to care for ourselves, to have empathy for ourselves, and rise up against oppression. And that's why I am here today, not to be some legal, you know, expert on the law or something, but to encourage people to rise up against oppression and work together in mutual aid for each other's benefit. Question mark, I don't know what I was going to do with this slide, but you know, the one thing I'd like to say regarding a question mark is that some people feel that, you know, when we feel down or defeated, sometimes I hear people say, oh, change is impossible. Well, I would counter that change is inevitable. Everything is in a constant state of change. And the question is, how do we harness that change for people's liberation and housing liberation? And I appreciate that all of you came here today and considered that some of my opinions might have some value and might assist in some of your work and meeting your needs. So thank you. And I am done. And I don't know, I didn't stop for questions because I was looking at my screen. So I guess we could do whatever you want to do next, Christine.
I honestly am not sure if we will be cut off from the connection, but we still have people tuned in. And so I think it would be a good idea to take a run at some of the questions. People can check out as they are and just be aware that we might lose our connection. Somebody else might be in line for the Zoom.
There's no one in line for the Zoom.
We're good?
Mm-hmm.
Oh, thank you, Tia. Did you want me to put the questions forward, Stephen, or did you want to take a look and see which ones?
So I'm going to scan for question marks and just start answering questions if that's okay with you.
Sure.
Okay. So, and you know, if I miss your question, just put your question back in again so I see it, you know, again. So the first question is, how would you know if a property is abandoned through assessor records? So the assessor records is not a good place to know. Let me think. So the assessor records, I don't go to the assessor records to find abandoned properties. You know, the first thing you want to do is do a visual inspection. And what I do is what I've done and what I recommend is thinking about what neighborhoods you feel like you'd like to be in, where you want to, you know, what physical place you want to be. And I encourage people to go block by block and just inspect houses visually to see if they're vacant, and then to look for signs of abandonment. That's what I recommend. And then the assessor records for me is really to just find out at that point, to find out who the owner is and then approach that person and try and find that person. So if the property is vacant and it appears abandoned, and I go to the owner, if the owner, I'm trying to think of any kind of circumstance. I'm sure there's some circumstances where the assessor's record would tell you that it's abandoned. But if one of the key ways is if it's vacant and it's been vacant for years and there's no utilities and it's all these signs of abandonment, and the assessor's record states that the owner's current address is the property itself, then that kind of indicates that it's probably abandoned, because there's no way to approach the owner at that point. So the only way to get the owner involved is to occupy it at that point. So, another thing that people should look toward is the tax collector's records. So if a property is abandoned, generally no one's paying taxes. If someone's paying taxes, then it's probably not abandoned. So that's what I would look for. All right, next question. And if you have follow-up questions, add them, because I don't know if I might not answer your question fully. So let me take. Okay, what would you ask the owner in that case, or how would you approach it? Not sure what case this is referring to, because this was in reference to something that I was saying at the time, I think. Do you have any idea what this was about?
Yeah, I think it was when you were saying, do due diligence and make every effort to reach out to an owner. So I think the question is, what do you say?
Okay, great. Thank you for that. Well, I mean, I think it depends on the situation. I mean, but what I've historically said, and I'm not going to tout this as the truth, because what I find is that most owners are really hostile. So, but I've heard that there's exceptions, but basically you just say, hey, can I occupy your house? And however you pitch that, but you're basically offering your services to the owner to manage their property or assist them with whatever problems they're facing in exchange for utilizing it as shelter. So basically you're offering to be their property manager. Sometimes I've approached owners and saying, hey, do you want to sell the property? But a lot of these property owners are already getting a lot of that, and are already tired of it. So really, being a property manager might be what they actually need. And so that's kind of what I've said is hey, and if you want to be and how you pitch it is up to you. What do you think is a winning case? If you're hey, my family and I are, having a tough time, could you help us out? Maybe that's going to work. Or I'm a very motivated person who's very responsible, and I see this as an opportunity, and I think we could, you could be a hustler and be I'm, this is an opportunity. This is a win-win opportunity for both of us. So I don't know.
I have a follow-up to that one, Stephen.
Oh yeah, maybe you have a better.
No, I'm just saying if you do get permission though, does that not thwart your efforts? The possibility of adverse possession, because then you are on the property with permission rather than being there.
Yeah.
Hostily. Yeah.
Yeah. If you get permission to be, if you have permission, okay, thank you for that question. You cannot adversely possess property if you have the permission from the owner to be there. And that's a kind of a slippery slope. Obviously if you're a tenant for 5 years, you don't own your house. So it has to be open, notorious, hostile, and continuous occupation. And what that means is you can't be sneaking around. You got to be visible. It has to be something that the owner should know that you're there, because if the owner doesn't know, then that's a no-go. And so there needs to be a reason to believe that a reasonably diligent owner would notice your presence there. So if you're sneaking in through the back and trying to be really, sneaky, that's you're going to lose. And so likewise, if the owner shows up and says, I grant you permission, then, at that point, you're not going to be an adverse possessor. At that point, you're a property manager or a guest. You're not even a tenant unless he or she or they take money from you. So the thing about this is, though, I mean, I guess in theory, the property owner could say, I give you permission to be here. And then you could say, I reject your permission because I am being open, notorious, and hostile. And that's, that works. You could still claim adverse possession, but I would not recommend that, even though that's legally, a theoretically legally valid. If I always encourage people to have if the owner is not, you know, if you're an occupant and you have no legal rights other than adverse possession, dollars to donuts, you're better off working with the owner if the owner is willing to provide you with some reasonable agreement to occupy the property with their permission. I would never recommend, you know, just entering into an antagonistic relationship with somebody who is likely a true owner. I mean, if they're full of shit and they're just making stuff up, then they may be trying to pull one over on you. So I would look to People v. Lepczewski for that, because that's what Lepczewski did. He squatted a bunch of houses and started renting them out and like kept the money. And you know, so I, aside from that caveat, I would encourage people to work with property owners unless you really just for some reason part of your strategy is to antagonize somebody. I don't know, and fail at your occupation and possibly, you know, be liable for something. I mean, I don't know. There's all kinds of tactics and strategies out there that I could imagine exist. So there was something about a farm. Can you claim use as a farm or something else for part? Yeah, any property can be claimed for adverse possession, you know, and the only caveat is that, you know, you can occupy any land unless it's owned by the government, you know, and then that's any government, local, county, state, federal government. One caveat I'd say about the farm thing is that what that brings to mind is that the continuous aspect of it. So, you know, in a farm, you know, often that's in rural land. And so if you are just there one day a year, you're not going to succeed. You're going to have to be farming or doing something on the land that is consistent with the type of use that would be reasonable on that land. So if you have like one of the examples that's used in law school is if you have a ski cabin and you go there, you know, most years to ski, but you're just there for a couple weeks, that is continuous because that is what a ski cabin is used for. However, if it's farmland and you're there just 2 weeks a year, that's not continuous because a farmer has to both sow the field and reap the field. So you have to be, so there's more of a requirement. And that's the same for housing generally. That, you know, if you're in a residential housing in the city of Oakland, you're not just there one day a year. You have to be there like more consistently with what a person uses for residential purposes. Does listing an address different from the address on the property ever create problems? Do you fill out this form before or after occupying? Yeah, that, you know, that's interesting because if you're talking, and I think she's referencing the, you know, the Revenue and Taxation Code 610B3 request form that I put up. And that form is, you provide the assessor with the information, and it, you know, it is conceivable that if the information doesn't match their records, that it won't actually show up in their database. So so I would think that it's the best thing to do is to make sure that whatever address is in the assessor's records is the address that you use. And you have to, and the main thing though is you need to use the same parcel number. That's the most important thing on that form, is that the parcel number matches the parcel that you're on. So, and the funny thing about physical addresses is that when you go on the assessor's map and you look at a property, you could find it by looking up the parcel number, and they have maps at the assessor's records department. And what they'll do is often give you a range of possible addresses. So you know, you might have a property that can be 610, 612, 614, 616, etc. And sometimes the assessor's maps are clear on that, and sometimes they're not. And so what I found though is to establish an address, it's all about, you know, figuring out something that's reasonable based on the assessor's maps, picking something, because if you don't have an address and you can't figure out what the historic address is, like for like an empty lot, for example, like we you know, on empty lots, we have to look at the assessor's map because it's impossible to find anything. And then you just pick whatever address seems reasonable. And then you just have to grab the mail carrier and say, hey, I have a mailbox here and this is it. And then at that point, the mail carrier is aware that you get mail there, and then you can maybe send mail to yourself just to like help get them, and that would establish your possession as sending mail to yourself. But yeah, I don't know that it really creates any problems though, too much, except for sometimes, if you don't, the mail carrier won't deliver your mail if you don't get it right. And I guess it could cause confusion. It does cause confusion from time to time when, in court, where one attorney is saying, oh, this is like, 3,200 MacArthur, and then somebody else is saying, well, it's like 600 Martin Luther King Way Jr. if it's a corner lot or something. And then that but that's kind of like a small problem. Who was legal counsel with last LAN? I'm not sure if land action is what they're referring to with LAN. Do you know? Does anyone?
I think that's when the question popped up. Yeah, when you were talking about it.
Yeah, our attorney was Heather Frankel, who works at the Homeless Action Center, HAC. She was great. Yeah, I think that, HAC is a great place too. And if you're homeless and you need support, it's a great place to go. But she doesn't litigate these cases anymore. So I don't know, I think that, I don't know who, I think that, I don't know, it's finding attorneys is just to get interested in these things is just so difficult because, it's just so much work. And the only way an attorney could get paid is if you win your adverse possession claim and then they put a lien on your house or something, and then like that's problematic. And maybe a land trust would pay them off if you work something out. Or if it's a civil rights lawsuit with the homeless encampments, they're looking to win the case against the city and then get paid by the city for their fees. But the problem is that attorneys don't see these as winning cases, and all they see is a lot of work that's not going to succeed, which is why we've always represented ourselves, because except for land action, always represented ourselves because it's such an uphill battle. I mean, the law as it's stated, the law as it's historically applied supports everything that I've been saying, but the courts don't care. The courts just side with whoever has the most money or who has the most status generally, and they'll give the property to someone who doesn't even own it, just because they are part of the same they have the same status or class as the judge. So it's crazy what I've seen happen in court. Yeah, some comments here. Which code was just mentioned? I think someone responded. Is your research available anywhere for us to look through and learn? That's actually, yes. Blog Squats. Oh, somebody put it. Blog Squats.
I provided it. Yeah.
Yeah. All right. Cool. Thank you. Thank you. I'm glad that you did that. Let's see. Questions. I'm trying to go through this. And all right. Question marks. Okay. Please spell people v. Lepchesky. Lepchesky is Lapchesky. Lapchesky. God, I feel like I have so much useless information in my head after all of these years of just case names. So those are all the questions. Now it's time for the dance party, unless people want to throw some more questions up there.
Thank you so much Stephen. Thank you so much, Stephen. We really appreciate it.
I've overwhelmed you with like nonsense.
No, I did want to say something about representing yourself in court, because Stephen, like, nudged and encouraged, and because it was so hard to find legal counsel, my family, I did that for my family. And that process, I just want to share with people, was so anxiety producing. But part of what made it so is that when you engage the court as a citizen and not an attorney or a legal professional, and you bring your emotion because you have so much at stake, they don't really care for that. Like, they didn't have a great deal of patience, with lots of vigilance and camping out and like being hyper aware at every turn, and going to the recorder's office 3 times a week, and following, some of the tools that Stephen has developed. We were able to stay in the house for 9 months, and eventually negotiated a settlement. So we got some money on our way out the door. But yeah, that was, oh my God, like representing yourself when you know your family's housing is at stake is incredibly stressful. I just want to say that.
Yeah.
And the court does not receive you well.
And I also want to note, I studied law through the Law Office Study Program, and you can, if you find an attorney, I just had a friend who knew an attorney who never represented me, but was like willing to let me like sleep on his couch when I was homeless. And I basically squatted his law office, and he, with his permission, of course, and studied law under what's the California has this amazing thing that I think just goes back to like them not having any kind of government structure for a while here, when early days of California, but the Law Office Study Program, where you can, if you're mentored by an attorney, you can become an attorney yourself by studying law for 4 years and taking the bar exam. Of course, I did all of that, took the bar exam, passed the bar exam, and then the state bar said, well, but wait a second, you're that squatter guy who was convicted of trespass, and so we think you're we think you're immoral, and so we're not going to let you practice law. So if you don't stick your head up, and if you don't get yourself if you don't go on CNN like I did, you'll probably be okay. But yeah, so and Selk is an amazing resource. The Selk apprentices created the website likelincoln.org, and and a lot of the people are studying law through the Law Office Study Program. So I'd encourage people to maybe reach out to the National Lawyers Guild and just kind of, join the National Lawyers Guild and show up to their meetings and just say, hey, I'm a legal worker, and just grab attorneys that are hanging around. And a lot of the attorneys that represented me in our conspiracy charges and also on these homeless encampment cases are National Lawyer Guild attorneys. And something I've been advocating is that if we can't get attorneys for these actions, we can at least have homeless people become attorneys and work with the guild members to mentor them. So I'd encourage people to stay engaged with Selk, to hustle lawyers at the National Lawyers Guild to show up for the movement and to mentor poor people and people of color, and do the right thing so that we can really not deconstruct what the legal profession is and what our legal system is, and deconstruct it and confront it with its own hypocrisy is one of the things that I think about, because a lot of what we're doing here with these laws is really just confronting the system with its own hypocrisy, because they have this whole idea of the system that's egalitarian, but it's really meant to extract resources, enslave, and colonize, as I said at the beginning. So I encourage you guys to stay engaged with Selk and other allies and use those resources. And I guess I don't know if I have anything else to say, but thank you, Christine. Thank you, Selk and Sustainable Economies Law Center. And I want to thank everybody for coming out. It's really cool that there's like over 30 people here.
Oh, there were quite a bit more earlier. And thank you, Stephen. And for those that are still with us, I hope you'll join us for days 2 and 3 of Thanks Teaching. And I was so happy to be able to bring this content to Selk, and I'm so happy to be part of the Radical Real Estate Law School program, which is what Stephen was talking about, the Law Office Study Program. So thank you everyone for joining us, and we'll look forward to seeing you soon. Thank you, Stephen.
Bye.
Thank you, Stephen.